An Introduction to Constitutional Law, 100 plus Supreme Court cases everyone should know, by Randy Barnett and Josh Blackman. Clear and present danger. Schenck versus U.S., 1919. Debs versus U.S., 1919. Abrams versus U.S., 1919. Gitlow versus New York, 1925. And Stromberg versus California, 1931. Throughout the 18th and 19th century, the Supreme Court played virtually no role in enforcing the free speech clause of the First Amendment. These doctrines developed remarkably late in our history. In this topic, we will discuss the origin of the judicially enforced free speech protections in the early 20th century. During World War I, the Wilson administration prosecuted war critics under the Espionage Act as a means to silence them. In 1919, the Supreme Court considered the constitutionality of 3 sedition trials. Justice Holmes wrote the majority opinions in the first 2 appeals, Schenck versus U.S. and Debs versus U.S. Both cases, decided in March 1919, upheld the prosecutions. In the third case, Abrams versus U.S., Justice Holmes dissented and found the prosecutions were unconstitutional. Let's start with Schenck. In this case, the defendant circulated literature arguing that the military draft violated the 13th Amendment. Schenck urged people to resist the draft. The Wilson administration charged him under the Espionage Act with, quote, obstructing the recruitment and enlistment service of the United States when the United States was at war with the German Empire. Schenck argued that the prosecution violated the free speech clause of the First Amendment. Justice Holmes, writing for a unanimous court, upheld the prosecution. He explained that during ordinary times, the defendant would be permitted to oppose the draft. However, quote, the character of every act depends upon the circumstances in which it is done. Next, Justice Holmes offered a very famous analogy that is often misunderstood. He wrote, quote, the most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic. But notice he referenced falsely shouting fire in a crowded theater. It's perfectly okay to shout fire in a crowded theater if there is a fire. Finally, Justice Holmes offered another famous test. The question in every case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. Here, the circumstances were dire. When a nation is at war, many things that might be said in time of peace are such a hindrance to its effort that their utterance will not be endured so long as men fight, and that no court could regard them as protected by any constitutional right. Therefore, Schenck's prosecution was constitutional. To this day, clear and present danger is a memorable phrase. But in the 1920s, it was merely a colorful term for what is known as the bad tendency test. That test allowed the government to ban speech if the natural and probable tendency and effect of a publication are such as are calculated to produce the result condemned by the statute. Under this relatively deferential test, the defendant's criminal intent is inferred from the speech's tendency to lead to violations of the law. 5 decades later, the Supreme Court effectively overturned this standard in Brandeis versus Ohio, holding that the government cannot, quote, forbid or prescribe advocacy of the use of force or of law violation except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. In the second case, Eugene Debs was the presidential candidate of the Socialist Party. He gave a speech to a crowd in which he advocated socialism and argued that the war against Germany was unjustified. He too was prosecuted under the Espionage Act. Once again, Justice Holmes wrote the majority opinion upholding the conviction. The court found that obstructing lawful government recruiting was not protected speech. Holmes wrote that Debs' purpose was, quote, to oppose not only war in general, but this war, and that the opposition was so expressed that its natural and intended effect would be to obstruct recruiting. 8 months later, in November 1919, the Supreme Court decided Abrams versus U.S. In this case, the defendants urged factory workers who made munitions for the war to go on strike. The court upheld the prosecution by a 7-2 vote. The majority found that this case was similar to Schenck and Debs. Justice Clarke wrote, quote, the manifest purpose of such a publication was to create an attempt to defeat the war plans of the government of the United States by bringing upon the country the paralysis of a general strike, thereby arresting the production of all munitions and other things essential to the conduct of the war. This time, Justice Holmes dissented, joined by Justice Brandeis. Justice Holmes did not question his previous majority opinions. Rather, he found that the Abrams prosecutions crossed the line he drew in Schenck and Debs. Specifically, Holmes found that the Abrams defendants did not obstruct the lawful military draft. He wrote, quote, it is only the present danger of immediate evil or an intent to bring it about that warrants Congress in setting a limit to the expression of opinion where private rights are not concerned. In other words, this case did not present the same type of clear and present danger. He also doubted whether the defendants had an intent to interfere with the war effort. Quote, it is evident from the beginning to the end that the only object of the paper is to help Russia and stop American intervention there against the popular government, not to impede the United States in the war it was carrying on. Next, Holmes provided another famous principle that animates our free speech jurisprudence. Quote, the best test of truth is the power of the thought to get itself accepted in the competition of the market. This became known as the marketplace of ideas theory. Study guide. Holmes adopted the marketplace of ideas concept from British philosopher John Stuart Mill. Can this theory be reconciled with Holmes's claim in Lochner v. New York that the 14th Amendment does not adopt Mr. Herbert Spencer's social statics? 6 years later, the court decided Gitlow versus New York. In this case, the court upheld the challenge restriction on free speech. However, the opinion is noteworthy because it applied the First Amendment to state governments via the Due Process Clause of the 14th Amendment. Study guide. The First Amendment provides that Congress shall make no law abridging the freedom of speech. Does this provision impose limitations on the state? What effect does the 14th Amendment have on this question? New York convicted Benjamin Gitlow of criminal anarchy. He distributed socialist literature. Justice Sanford wrote the majority opinion. He considered whether the New York law, quote, deprived the defendant of his liberty of expression in violation of the Due Process Clause of the 14th Amendment. The court, quote, assumed that freedom of speech and of the press, which are protected by the First Amendment from abridgment by Congress, are among the fundamental personal rights and liberties protected by the Due Process Clause of the 14th Amendment from impairment by the states. Once again, Justice Holmes dissented, joined by Justice Brandeis. He wrote, quote, there was no present danger of an attempt to overthrow the government by force on the part of the admittedly small minority who shared the defendant's views. Therefore, he thought the conviction was unconstitutional. Stromberg versus California is the final case in this topic. Here, the Supreme Court declared unconstitutional a state restriction on speech for the first time. Stromberg was convicted of displaying a red flag, an anarchist symbol. The Supreme Court reversed the conviction. Chief Justice Hughes wrote the majority opinion. Quote, The maintenance of the opportunity for free political discussion to the end that government may be responsive to the will of the people and that changes may be obtained by lawful means, an opportunity essential to the security of the Republic, is a fundamental principle of our constitutional system. A statute which upon its face and as authoritatively construed is so vague and indefinite as to permit the punishment of the fair use of this opportunity is repugnant to the guarantee of liberty contained in the 14th Amendment. It was not until 1965 that the Supreme Court for the first time declared unconstitutional a federal law for violating the freedom of speech.